All right, there's a big judgment, an order in fact coming in from the Delhi High Court, and this is about the arbitration award that has been set aside. Delhi High Court sets aside the 15,000 crore arbitration award in favour of Devas over sudden termination of the agreement by ISRO's commercial arm, Antrix. So those are the details which are really coming in. My colleague Ananya is getting us more details on the story. Ananya, this has been a very, very high-profile matter, and the manner in which the agreements were terminated forms the heart of this issue. Tell us about the grounds on which the Delhi High Court has cancelled this award.
Well, yes, remember, Anusha, this is a 11-year-long dispute that's been pending between the ISRO's commercial arm, that is Antrix and Devas. And remember that after a lot of time now, in fact, the court has, in fact, suspended this whole complete arbitration award of 15,000 and has, in fact, given out a very, very detailed judgment into this aspect of this case, and clearly amounting to what can be released.
Ananya Bhatnagar getting us all the details on that very important story. We'll try and just get across to him once again. There's a technical issue. But the 2005 satellite deal between Antrix and Devas had formed a critical bone of contention before the NCLAT and various commercial tribunals here in the country. The matter had also at one point reached the Supreme Court. Now, this pertains to cancellation of certain deals that had happened. The contracts were actually initiated during the UPA government. The tussle is a fallout of the cancellation of a deal. This happened back in 2011. By then, UPA government citing requirement of satellite spectrum allotted to Devas for security purposes. Ananya is back with us on the broadcast. Ananya, let's tell our viewers and let's simply explain this to our viewers. What exactly was the reason that the two were locked in a terse legal battle that lasted for more than a decade? And what are the grounds on which the Delhi High Court has set aside this arbitral award?
Well, yes, I'll read down a particular portion of this order for you,
Sure.
Anusha, and this is that it is held that a product of fraud in conflict with the public policy of any country, including India. The basic notions of morality and justice are always in conflict with fraud, and that allowing Devas and its shareholders to reap the benefits of their fraudulent action would send another wrong message, namely that by adopting the fraudulent means and by bringing in India into an investment in a sum of rupees 579 crores, the investors can hope to get tens of thousands of crores of rupees even after siphoning off, in fact, 488 crores. In view of the above, the objections filed by the petitioner under Section 34 of the Act are allowed, and it is held that the impugned award dated 14/9/2015 suffers from patent illegalities and fraud and is in conflict with the public policy of India. The petition is accordingly allowed, and the impugned order dated so-and-so is set aside. So basically, the top court is saying that there have been fraudulent practices into this particular case, and hence the arbitral award has been set aside. And in fact, a very, very big relief coming in now from the Delhi High Court. Anusha.
So, under the Arbitration and Conciliation Act, there are very, very limited grounds under which an arbitral award can be set aside. Arbitration is a process by which two companies get together on a table and in a quasi-judicial process try to solve their commercial disputes, largely done for commercial disputes involving big organization. In this case, Antrix versus Devas. Now, the court here goes on to say that the earlier award that was given is in conflict with public policy. Now, this is one of the key grounds on which the courts in the country, especially the Supreme Court and the High Court, are empowered to set the award aside. And that is what the court has done today in this case. Clearly, it's done in rare cases. It's done in cases where the court thinks that prima facie an arbitral award does not sit well with the public policy of India or is detrimental to the national or commercial interests of the country. Ananya, also take our viewers back in time. This is a dispute that has been going on for a very long time. What were the agreements that were the bone of contention between these two companies?
Well, yes, Anisha, remember that this is almost 11-year-long legal battle between the ISRO's commercial arm, Antrix Corporation, and Bengaluru-based firm Devas Multimedia. And the Supreme Court had earlier issued some orders and dismissed Devas' appeal against the tribunal's 2021 order that it should wind up operations on the ground of fraud. In fact, the matter is a commercial dispute that arose between Antrix and Devas in February 2011 when in fact 2005 agreement with the latter was into a big hoax, and in fact it has been said that these agreements have now been into a lot of big questions, and Later on, long legal battle continued for 11 years, and now clearly a big relief coming in from the Delhi High Court. Remember that the matter also in January 2021 had reached the NCLT, that is the National Company Law Tribunal, wherein Antrix approach seeking liquidation of Devas on the grounds that the company was incorporated with fraudulent motives. So now definitely end coming to this Antrix Devas dispute, Anusha, somewhere or the other, with the center's big win into this particular case where the arbitration award has been set aside. However, we might see that Devas can approach against this order before the topmost court of the country and might file a petition seeking a review of the same.
Now, as my colleague Ananya was pointing out, this is a very long dispute, about 11 years, and it has been running through different tribunals and courts of this country. The NCLT, the NCLAT, the matter reached Supreme Court at one point in time because there were winding up orders that were given by the NCLAT, and that was in fact upheld by the Supreme Court. Now, the arbitral award under Section 34 of the Arbitration and Conciliation Act can only be challenged if it's detrimental to the public policy and morality of the country. And it's on exactly those grounds that the Delhi High Court has set aside this huge tribunal award. And yes, it's a big relief coming in for the petitioners in this case. With that, we're slipping into a very short break.